Because the court system is just so slowed down now and it's getting worse and worse, the coronavirus and everything else, that I think this only helps at the very least to try to at least move things along a little bit faster than it would in, say, the court, in a court hearing.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Texas attorney Lisa Renee Wilcox walks through the alternative dispute resolution clause in a trademark assignment and license agreement from R.R. Donnelley. The goal of these clauses is to maintain relationships while cooling down the inevitable conflict. This might be more dream than reality when you're drafting, so let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose in the show is exactly what it sounds like. We take contracts, we beat them up, we're mean, occasionally nice, but mostly mean because it's funnier. I hang out with smart people like my friend Lisa Renee Wilcox. Lisa Renee, how are you today?
I'm doing well, thank you. I appreciate it.
We are glad to have you here. We're talking about a subject that is of interest, especially as we talk about this sort of more holistic lawyering, which is this document. Let me show you guys. This comes from an agreement with assignments and licenses, and we're going to compare it to others. But specifically, we're going to talk about this dispute resolution section. Lisa Renee, before we dig in, what is this section? When are we going to see it? Why are we talking about this?
So we're talking about this to try to resolve, particularly like two different individual companies working together to resolve something prior to litigation, that hopefully they can get it resolved with the CEO and CFOs so that they don't have to spend all that time dragging it through the courts. And so this makes them step up to the plate early on and give each other notice of what the problem is.
Got it. So anytime you have any kind of a relationship, we can talk about my marriage later if you want to, there will be, the more you have contact with people, as my anthropology professor used to say, the more, opportunities for harm. And so these are ongoing business relationships. They're opportunities for harm. They don't have to lead to a divorce.
Exactly.
So we're going to find ways to solve that. But before we dig into it, what about you, Lisa Renee? What is your background? What brings you to documents like this?
So, but before law school, I owned a bar and nightclub in Florida, and so one of the things.
So you know about both disputes and divorce. Go ahead. Exactly,
and part of that, when I got the bar with the first property that I was leasing, it was eminent domain for a mini mall in Tampa. So I had to experience that, and dealing then with the landlord also. It would have been nice to have been able to negotiate ahead of time and not drag it through the courts. And so that, I learned really early on before law school how much that can cost. So that was a big thing after I sold the bar, was maybe I should go to law school now. So that was a big reason why I did that.
Gosh, I thought all of us did because we all have history degrees and don't know what to do next. But I like your more noble reasons. All right, well, we're going to dig into this thing. I do
have a history degree too.
Yeah, right. So bar background and no choice. Maybe the bar was helpful while getting I don't know. But we're going to dig into this thing. Before we do, just briefly, tell me, Lisa Renee, about this document. So we're looking at this agreement, this assignment, trademark assignment and license agreement. Just give us quick context. What is this document before we dig into the dispute resolution section?
So it's between these two companies, R. Donnelley Sons and LSC Communications, and LSC has tons of trademarks that they've filed. So what they're doing is licensing the rights to this other company to use them, and part of that is then making sure if the company that's using the trademarks doesn't do something right, they can resolve it pre-lawsuit.
Got it.
So it spells out then where and what laws would apply, which is big in the world of, especially starting to do more international law for companies and with trademarks and across the world now with Amazon and everything else. So
got it.
That's a big reason.
So in Article 6 of this document, under the heading Dispute Resolution, they give a bunch of different options for alternative dispute resolution and ways that, you're dealing with these issues before they go to court. So let's just go down them. What I'm going to do, Lisa Renee, is lead you through each of them. We'll start with 6.1, negotiation section. I'm assuming that this is like in order of preference, that they'll list each of these because this is the order they want to go in. So let's start with negotiation. Tell me about this section. Do you like it? Do you like the way it's written?
I like the way it was written. I do think that they give a little too much time of like 45 days with the notices, and I think they drag it out a little bit too much. But otherwise, I do like the fact that they have to give each other written notice and set a time to really set and try to figure out if they can resolve it dragging it through attorneys going through mediation and arbitration and all that. If so this is a preemptive way of trying to resolve something if they can in advance of that.
Yeah, I'm curious, and maybe we could talk about this with the other stages. Like, would a business owner in this situation not hire a lawyer to send this letter, right? Like, in a way, we're avoiding court, but we're creating costs, I assume, with each of these processes, because you would get a lawyer to come and tell you how to do these things anyway. I mean, similarly, right. I might move you down to 6-2 in the mediation. I mean, I've dealt with mediators. I've never gone to a mediation without having a lawyer with me. What do you think about 6-2? Is it accomplishing the ends of avoiding court-like processes?
I think that it can help. Unfortunately, too, you're still talking about entities, and so they can't represent themselves and without potentially violating an unlicensed practice of law. So that's why this is helpful for the companies to maybe save some money on having the filing fees for the litigation and everything else in the meantime. And now that with the coronavirus and everything too, I'm thinking what I would have added now into these agreements, especially with the mediation, is doing it via Zoom meeting, and so that they could be anywhere in the world at that point, working with the mediator. Yeah,
they do agree. They agree to comply to the commercial mediation rules of the American Arbitration Association. So there's some background rules that presumably somebody could look at. But I was interested in this sentence. It said the parties agree to participate in good faith in the mediations and negotiations related thereto for a period of 30 days. Do we have any idea what good faith means in this context, or what that requirement is?
Well, that's an issue I think that should be laid out a little better. But no, I mean, good faith meaning they actually presented their side of the argument or something at that point. But, right. And then hopefully keep it confidential. But, that still, could be an issue if they don't. And that's why I'm thinking even getting past the negotiation stage, which was too long, 45 days, I'm thinking get on to mediation if you can't get it resolved. 45 days is a long time in the scheme of the world nowadays.
So am I right that it was 45 days for negotiation, 30 days for mediation?
Yeah, that's correct.
Then if that doesn't work, we jump down to 6-3 for arbitration. Again, some background rules. Right. Some references to agreements outside of this. What do you think of this arbitration section?
I think it's pretty good. I mean, unfortunately, now then you're having to pay for 3 arbitrators to then be present for it. So that's where I think it starts to get a little more expensive versus, just maybe having them just agree on one arbitrator versus having a panel of 3. I don't think is necessary in the scheme of things, but that's where I think it could start to be more expensive.
Yeah, the language, just to underline it, says there shall be 3 arbitrators. Each party shall appoint 1 arbitrator within 20 calendar days of receipt by respondent of a copy of the demand for arbitration, the 2 party-appointed arbitrators, et cetera, et cetera. Then we're going to add a 3rd person by drawing straws or something. There's a talk about strikes, like being able to strike people's arbitration. I mean, this is a lot of process for a process that's supposed to remove a bunch of the process, right?
Exactly. So that's one of the reasons I found that I didn't really necessarily like this clause because of it making it so much more of a process than it probably needed to be to try to get it resolved. And then they could still go to litigation if they wanted after that even. So, that's so that's the one issue I could see it in. It just it seems like it also just continues to drag out this dispute because of the number of days. Now you're like, after the 60 and the 45 days and now this, it's, to get a resolution.
Yeah.
It takes a long time with this agreement. So
6-4 is called the arbitration period. And what it says on there is any arbitration proceeding shall be concluded in a maximum of 6 months from the commencement of the arbitration. So we were dragging on and on. Did you see, I know that you had looked at some other agreements on Law Insider, and before we jump down to some of these other background rules, did you see in any of the other agreements that you saw maybe better language or some learnings from other documents that you might be able to create better processes than this?
I would, well, one on the other agreement that I had, the Kraft Foods, I like the fact that they, it's a much quicker, they have a 15 days for the initial representatives to try to get it settled versus this, longer time period that this has in this licensing agreement. And the Kraft one, it just seems that it helps move things along a little faster, and it also allows you to arbitrate or litigate. So, if you do find that you just need to go ahead and file the lawsuit, this allows you at that point, after you've at least attempted to settle the case, then you could just go ahead and litigate it at that point versus dragging it out in this 3-person arbitration and having to pay for all those arbitrators and everything else. You could just go ahead and move it into the court at that point with that one. And then I also like that, I like that it is under the International Center for Dispute Resolution. So that way now, if you're dealing with companies, it seems now most companies have things going on all over the world. And so, especially with Amazon and those different companies where people are now exporting and importing. So that's why I'm thinking it would make sense to be able to use the international scope versus just narrowing it down to the U.S. arbitration. And so, I do like that. It allows them still to, use New York law too in it, but as opposed to, so at least what laws you're dealing with. You're not trying to negotiate that part of it, but. It helps, I think, to have the international arbitration.
Right, to clear that up early. Well, getting back to the LSC agreement, it does in 6.5 talk about some background rules. And so you mentioned before the requirement to keep things confidential. There's other stuff in there about making sure people know this is negotiations for the purpose of Federal Rule 408. Of evidence and these background rules. It's a long paragraph. Do you think this suffices? Do you like 6.5 and the way they talk about the background rules in any of the, whether you choose negotiation, mediation, or arbitration?
I do like that because it lays out everything. So you know exactly what you're going to be dealing with at the very least, not having to guess, about the rules and what's going to be happening during this procedure. So that at least I think is useful, especially when you're talking to the CFO and COOs of these companies and trying to get them on board and understanding what they're trying to get resolved. Right. I think it's useful.
Right. And as I'm thinking about this, as I sort of step back from the particulars of this agreement and the Kraft agreement and other agreement, we'll make sure that you guys have access to over at lawinsider.com/resources to these particular agreements. But as I think big picture, I mean, I know that what you're dealing with is these businesses that are trying to avoid too much process with the idea that, process, I'm assuming, is more expensive. It takes longer. It makes it more likely that a given dispute is going to become a divorce, that they're just not going to be able to work together anymore.
Exactly.
I guess my question on the drafting side, on when a drafting lawyer steps into this exercise, drafting lawyers by nature are trying to predict all the bad outcomes. Isn't there a risk when you write these kinds of that you're basically going to create a process that is expensive and time consuming and more likely to lead to a divorce? How do you in the drafting exercise make sure that you're not creating a new crappy court system, basically?
Well, unfortunately, I think because the court system is just so slowed down now and it's getting worse and worse, the coronavirus and everything else, that I think this only helps at the very least to try to at least move things along a little bit faster than it would in, say, the court in a court hearing, and trying to even just get a hearing scheduled these days has been difficult too. So that at the very least, the parties themselves are working together to try to get something resolved and heard, and put in something in writing. And so I do like that it's, to a certain degree, I haven't ever seen, so when I started digging into these agreements and seeing it more spelled out, I started thinking, well, that does make sense for then everybody knows what they're supposed to be doing.
Right.
So there's no dispute there. And then if they don't do it, then they do still have a back, they could go and litigate it then at that point, essentially, if they didn't do it and follow the rules. So that's one nice thing is if they don't follow all the rules, then at least you've got to go then litigate it.
But I got to say, Lisa Renee, I'm just a pessimistic person, but I'm looking at situations like this, and when I would deal with divorces, for example, when I practice, being able to determine the difference between what's a legal problem and what's not, right? And when people come to lawyers in a divorce, like they're bringing the whole bundle of problems, but some of them just aren't legal problems. And I wonder if in a situation like this, if the exercise of trying to come up with all these rules is itself creating, the more you create, the more ground for conflict you're creating. Whereas, if we said, look, these are not legal, go figure them out, go get a business negotiator or whatever to come. And then once you guys come to an agreement, we'll turn it into legal documentation. I don't know. To a degree, I feel like that's what they're trying to do with mediation. But an agreement like this, I feel like you're really creating a lot of ground for fights. I don't know. What's your experience with that? Is my fear off base?
It depends on how good of a relationship the business has had it before. Right. I mean, exactly. So if they had a decent one to start out with, then typically they want to try to get it resolved and between each other and not have it all part of the public record. That's the other thing too, especially like when you're talking about these companies that are publicly traded. They're trying to keep it under wraps as best they can too. So that's one of the reasons I thought it's good that it's not just part of the public record immediately filing that lawsuit, that at least they could try to resolve it without having the whole world know about it at that point.
Yeah, that's a really good point. Like even the idea that maybe this creates a bunch of process, but what we know is that process is confidential. Maybe that's a good enough of a trade-off. I mean, that's an interesting point. Well, I think it's an interesting context in these companies trying to find ways to preserve relationships. We'll make sure, like I said, that these documents are available over at lawinsider.com/resources. But Lisa Renee, for people who want to reach out to you, learn more about your practice and how you help businesses with these kinds of conflicts, what's the best way to reach out to you?
At my email, typically Lisa at 3andrews.com.
Perfect.
And I'm happy to discuss. And my version of these clauses was a lot smaller back in the day. So that's why I found it's kind of interesting, though, to see the difference, with the bigger companies, because I represent a lot of smaller companies and they wanted it to be a lot shorter. I found. So.
And yet, no matter the size, you're still dealing with the same goals. Well, I appreciate that. It's interesting. Like I said, everybody go to lawinsider.com/resources. Also, if you want to be a guest on the Contract Teardown show and beat up contracts like we did today, just email us. We are at community@lawinsider.com. We'll see you guys next time. Lisa Renee, thank you again for hanging out with us. Y'all have a good day.